SJC-12335, Commonwealth v. Derek Scott.
Mr. Zeltzerman, good morning.
Good morning, Your Honor. May it please the Court, Alan Zeltzerman for Mr. Scott. This appeal concerns our attempt to seek a review of the lower court order denying our motion to access jury questionnaires that have been retained in the case. I want to first address the threshold issue of Mr. Scott's entitlement to review under GLC 211, Section 3. Then briefly discuss what the case is not about, then lastly discuss what the case is about and the interplay of the substantive rights involved here. If you look at my briefing concerning that threshold issue, I cite to Charpentier v. Commonwealth, where the court found it appropriate to review under GLC 211, Section 3 in a case where a defendant's motion for trial transcripts was denied as he sought to perfect the appeal of his criminal conviction. I can find no principled reason to distinguish Charpentier or Blazo v. Superior Court in principle, a case upon which Charpentier relies, from the issue presented here. Now, in my briefing, I discuss McMenamin v. Positemko. I don't know if I got that right. But I also want to turn to Planned Parenthood League of Massachusetts.
I guess my question is,
yes.
Why not, you're before the appeals court, you have a case pending before the appeals court,
Yes.
correct? Why not go to the appeals court and say, listen, I'm going to be arguing error with regard to the jury selection process, and in order to develop my argument, I would like access to the jury questionnaires. Why not go to the appellate body that'll be deciding the appeal as opposed to coming to us on 211-3?
Because if you look at the remedy I would receive there, for example, if the appeal of the judge's denial of the motion for jury access to the jury questionnaires is consolidated with our direct appeal of the criminal conviction, and in that appeal we prevail, that the appeals court agrees that we should at that point receive access to the jury questionnaires, what is our remedy? Would it be to refile the appellate brief in the case after I have a chance to go over the jury questionnaires and see if there's some relevant information there that I can use in crafting my appellate argument? There doesn't seem to be a procedure here in Massachusetts that would allow me to submit a brief on our direct appeal as of right.
What about the appeals court single justice?
This didn't seem to be the appropriate way to proceed before a single justice. This is not an interlocutory issue, for example. But we decided to proceed before a single justice here. But what would the remedy be? Would it be a motion under Rule 30B? I don't see how that would then lead to our refiling of the appellate brief. And on that motion, we wouldn't have, Mr. Scott wouldn't have, for example, the right under the Due Process Clause of the 14th Amendment and Article 12 of the Massachusetts Declaration of Rights to an attorney, and the right to the assistance of competent counsel. He wouldn't at that point have the right to a first appeal. That's, I think, what is at issue here. How can we somehow resolve outside of the mechanism presented through GLC 211 Section 3, the dispute here. I think it's also important to point out what this case is not about. And this case is not about a motion for relief from impoundment, for example, under the Uniform Rules of Impoundment Procedure. This case does not concern a motion filed under Rule 11 of those rules. And this case is dissimilar from a recent decision of this court in Care and Protection of MC, in which this court relied on Rule 11 and Rule 7 in crafting a way in the juvenile courts for parties in that juvenile court proceeding to access the material. If you look at the issue in that case, under GLC 119, Section 38, I believe, and Juvenile Court Rule 1-84. It's very dissimilar to the issue that we're presented here. If you look at the Rules of Impoundment Procedure, for example, I think if memory serves, it's Rule 1B9 under the definitions. As an attorney of record, I should be given access to the record, the case record, in our view, to the jury questionnaires that are part of the record on appeal. That's a distinction I want to draw, pointing out what this case is not about. It is about our attempt to access what we believe is the record. If you look at the rights involved, our right under the Due Process Clause to avail ourselves of our statutory right to a direct appeal in the case of Mr. Scott's criminal conviction, and to avail ourselves of the procedure set out in the Rules of Appellate Procedure. If you look at Rules 8A and 18A, we have a right to take a look at the record on appeal. We can find no requirement that we first have to state a good cause why we need to examine.
And you don't think those rules would permit you to file a motion, as the Chief Justice suggested?
You mean
Appeals Court?
file
A motion to gain access and to comply with 8 and 18A?
A motion with the appeals court to order the Superior Court clerk to comply with those rules. That would take us, I think, far away from the review that I'm seeking here. It could perhaps be a mechanism, but the direct appeal now has been docketed, and a stay has been entered as we await a decision of this court. I think it's also important, perhaps the court can tell me if you're aware of a case that would place on me the requirement that I articulate a good reason for reviewing the record on appeal. I can't think of one. That's an approach that the United States Supreme Court rejected in the transcript cases, and here it is 2018, we're referring again to the transcript cases when looking at this part of a record that has, I don't think, been litigated yet. Eskridge v. Washington State Board of Prison Terms and Paroles, for example, Draper v. Washington rejected that approach. Now, we can mention Mayor v. Chicago. And in that case, the state can seek, after a defendant claims a need to access record, the state can seek to, has the burden then to, when seeking to limit the access to records, to provide a good cause why. But I suggest that when you examine the Meyer case, Mayor v. Chicago, the Illinois court rules in that case are dissimilar from the rules here. I can find nothing in the rules of appellate procedure that would limit what constitutes the record on appeal. I don't know if there are any questions here.
Okay, I think your time is up. Thank you. Good afternoon.
Good afternoon, Your Honors. May it please the Court, Assistant District Attorney Dara Kesselheim on behalf of the Commonwealth. The Commonwealth respectfully requests that the Court affirm the order of the single justice, denying the defendant's petition pursuant to GLC 211-3, where the defendant did not demonstrate either a substantial claim of the violation of his substantive rights or the unavailability of another remedy. And I would start with the issue of the substantial claim of the violation of his substantive rights. That showing simply hasn't been made here. And I think the place to begin is with the faulty premise that the juror questionnaires are part of the record on appeal. They are not. The Massachusetts Rules of Appellate Procedure 8A defines the record on appeal as the original papers and exhibits on file, the transcript of the proceedings, if any, and a certified copy of the docket entries. The juror questionnaires, the confidential juror questionnaires, don't fall under any of these categories and are treated separately and distinctly by statute. The confidentiality of the juror questionnaires are governed by Chapter 234A, Sections 22 and 23. And Section 23 specifically provides that the juror questionnaires shall be held in confidence unless the court orders otherwise. It also provides for the destruction of the juror questionnaires that are retained after the final disposition of the case. That's different than we treat other aspects of the record. This is...
And by that, they mean the rescript on appeal.
Correct, which is not the same for other pieces of the record as defined by Rule 8A. And the statutes which protect the the confidentiality of the juror questionnaires do so with good reason. As Your Honor, Justice Gantz pointed out in your dissent in the Fujita case, 470 Mass 484, that's a 2014 case, jurors are the only private citizens that we force into service to the Commonwealth. And when we do so, we require them by law and make it a crime for them not to disclose highly confidential information, not just about themselves, but about their relatives. And we ask them for their employers, we ask them for their children and their number of children and their children's ages. We ask them for their past experience with the law, and then not just whether they've had past experience with law or law enforcement, but to describe that experience. So they're required to disclose often very intimate details about their lives, and they're done so after being told, both through the statute and the confidentiality notice on the juror questionnaire itself, that that material will be maintained in confidence and will not be a public record.
But they are shown to defense counsel. Defense counsel has full access to them during the course of the jury selection.
Yes, that's correct.
And there are times in which reference may be made to the content of such as, Your Honor, I see in the jury questionnaire that his brother was a police officer. Could you ask about that?
Certainly.
So it's not as if it's a black box.
That's correct. And it's not as if there aren't cases in which a juror questionnaire might become part of the record. So if there was something that came up during the voir dire process that made reference to the juror questionnaires or made some aspect of the juror questionnaires relevant to that particular case, then there would be the opportunity for the parties or the judge to mark a questionnaire as an exhibit and have it become part of the record. But they are not part of the record on appeal, as my brother
Could
suggests.
a defendant make a motion, a Rule 30 motion, and then part of that Rule 30 motion ask for discovery or ask for a questionnaire to be unimpounded or
I don't see
included?
why not. I don't see why not. And again, it's not that the trial judge here said there's no circumstance at all under which this confidential information would ever be disclosed. It's that the defendant made no showing as to why it should be disclosed in this case. So in order for a court, the statute, Section 234, Section 23, does vest some discretion in the court as to make an order when this highly confidential material should be disclosed, and the defendant made no such showing as to why it would be relevant at all in his case. So without having made any showing as to why this material would be relevant, without having requested, the trial attorney never requested that any of the juror questionnaires be marked for identification so that they would become part of the record. And there's no indication from the transcript that any of the juror questionnaires in this case would be relevant at all to the defendant's claim with regard to the misuse of a peremptory challenge. And under those circumstances, the trial court's order denying the defendant's motion was proper, and the single justice's motion denying the defendant's 211-3 petition was also appropriate and should be affirmed by this court. Unless the court has any further questions, the Commonwealth is content to rest on its brief.
All right, thank you.